We have here today, we brought William to make a presentation about all of the research that we have been conducting and how we are thinking about the problem of confidentiality and privacy. So he will make a presentation. How are you, William? Welcome.
I'm doing well. Hi, everybody.
Awesome. Well, share your screen and walk us through all of this.
So, like as Fede was saying, there's these questions around how one can handle confidential information in a system like Kleros. And he made all these points about okay, blockchains are very transparent and open. You see all the transactions, and all of that is true. It makes it very difficult to have secret interactions. You see all these kinds of privacy coins that you try to use fancy encryption techniques to get around the transparency of blockchains while still having secrecy. That presents the transparency of blockchains themselves presents a challenge. But I would say that even a bigger challenge for confidential evidence in Kleros and systems like Kleros is that Kleros is a crowdsourced system. If you have a dispute between Alice and Bob, and it's you have confidential evidence, which is relative to their dispute, they have business documents or whatever. Ultimately, if the crowd, jurors drawn from the crowd are going to make a decision for, what's the appropriate resolution to the dispute, they need to see that confidential evidence so that the evidence has to go to the crowd. And that presents intrinsic, very, challenges around how you can do that and provide good, cheap, crowdsourced resolutions while not just publishing the evidence. So currently, prior to case 146, but evidence in Kleros was always just published IPFS by default. It was made public, and as you can see if you followed history of past Kleros cases up to this point, most of the cases have been about things that are very public to begin with, where the evidence isn't very confidential. All these curation disputes about whether some public contract deserves a tag on a blog explorer, and the contract is already published, so there's nothing confidential about that. If you want to have confidential evidence, the natural thing to do is say, okay, I'm going to encrypt the evidence. I'm not just going to publish it unencrypted to IPFS. I'm going to do some kind of key exchange between the parties, Bob and the juror. They're going to come up with some way that they share some secret cryptographic key, and then Bob can encrypt the evidence and send it to the juror or jurors, and they'll be able to decrypt it, see the evidence, make a good ruling, and everybody else, they won't, it'll just be sort of garbled noise if they look at the encrypted channel. That's not so hard. That's one can add an encryption layer on top of Kleros. There's this extra infrastructure. It's not intrinsically difficult to deal with that. However, what is challenging is how to deal with leaks. What do you do if the juror just reveals the evidence anyway? Being in a cryptoeconomic system, how Kleros is built out of all these cryptoeconomic tools. A natural thing to do, in cryptoeconomics in general, is that if you have some action you don't want people to take, you make them stake a deposit, and then if they take the action that you don't want, you slash the deposit somehow. So a mechanism that we've thought a lot about over the years to sort of enforce a code of behavior on jurors is what I call the Juror Misbehaviour Court. So this is a mechanism which is V2 of Kleros is designed so that this can be inserted as a module at some point in the future. And the idea here is that if the juror does something that's against the Juror Code, they can be challenged by some observer, some challenger, maybe one of the other jurors, maybe one of the parties to the disputes, maybe a third party, who will place a deposit, and that deposit will be used to finance some secondary Kleros case. So it's some totally new jury is drawing some other court, a court that specializes in these Juror Code questions, and then they'll judge whether the juror in this case released this evidence inappropriately, and if the juror is convicted of inappropriate releasing of confidential evidence, a part of their PNK stake will be slashed. Maybe they get a negative SBT that will prevent them from being drawn again. I think there's black marks, so they can't come back. So that's a kind of cryptoeconomic tool that you can use to prevent people from inappropriately releasing confidential evidence. how can you tell if you just sort of see like the evidence like appear on the internet, it's like floating around all of a sudden, how do you know which juror published it? So here there are tools around what's called digital watermarking. You try to like the party to the dispute can run their evidence through some kind of digital watermarking software, which will basically make all these like small changes that are imperceptible to human beings. But like, if you run it back through the software again, you can kind of, pick them out. So things like adding a little bit of space between characters, small changes in fonts, things that like a human being won't notice. But like if you have multiple versions of the evidence that were sent to like say 3 different jurors, they'll all be watermarked in slightly different ways. And if you see that like one of them is floating around the internet later, you can kind of like run it back to the tool and pick out, okay, like because of this spacing, we know that juror A was the one who released the evidence. And then you get into all kinds of like cat and mouse games of like, okay, like to what degree can the juror reformat their document and try to delete the spacing? People who make digital watermarks try to be resistant to that, but there's it's a cat and mouse game. Like where like for one attack you have like counterattacks and things. So this is a useful tool, but like with limitations. And then like an approach that we've taken for these Junin cases, for like case 146, is to use an interface called Trezor. So Trezor is a Swiss company that like basically does encrypted document sharing as like a service, so that makes that's an interface through which jurors can parties can encrypt the evidence, which will go to jurors. Trezor offers like end-to-end encryption, so you can do this in ways that like the company itself doesn't see your encrypted evidence. They include watermarking features. So that is an option. They have features so that like jurors that are provided with this encrypted evidence can't just like download the evidence, like downloads are blocked. There's that in some sense, like that kind of feature is kind of in the philosophy of like Snapchat, or like a fancy version of Snapchat, where you try to like prevent people from saving the information on like a software level. That is obviously, has limitations, like what prevents someone from just like taking a photo of like the screen with their phone. On some level, it's intrinsically difficult to prevent that. But then you go back to like the watermarking features and things to try to like at least add some kind of resistance to such things, such attacks. Okay. And that's all well and good. If you have like purely cryptoeconomic kind of defenses against evidence being leaked, these like, okay, like if I release the evidence, I'm going to be slashed in the Juror Misbehaviour Court. Like that can be good for certain kinds of evidence, like low scale, like not so sensitive, not so valuable. But ultimately, the security you have is economic, as is the case in most cryptoeconomic systems. You have like, resistance of attack up to some like value. In Kleros, we have all kinds of like models around like, okay, like the resistance to the court depends on like how much it would cost to 51% attack the court. Like Ethereum itself has kind of similar economic models. Okay, like, like what are the costs to like try to like attack the consensus algorithm? You buying up a lot of ETH and staking in like malicious ways. And like here as well, it's like, okay, like I have some kind of like economic resistance. If, the evidence is leaked, juror will be slashed. That slash goes up to a certain amount of deposit that they've staked. Like ultimately you get into like things like, okay, like if a juror has like, say my like competitor thinks I have a case coming up soon and they want access to my confidential evidence, they can maybe try to stake in the court that they think the case will be in. And then if they like stake a certain amount, they have a certain chance of being drawn. And, like you have all these like subtle questions around like how much economic security do I have in like a given case? And if you have like very crypto use cases that might feel familiar to the parties, they might be okay with that, particularly if the evidence isn't too sensitive. If you have kind of, maybe like more enterprise use cases, people come from the Web 2 world, they're not like the most comfortable with like reasoning through like how much economic security they need. Then you really need systems that like are less open, where not just anybody can be a juror. Like you have some kind of mechanism in place so that like my competitor cannot just, like is vetted in some way so that he cannot register as a potential juror for my cases. And how can you do that? Well, conceivably, you could have some kind of like decentralized curation, maybe, like if you want to conform with the like regulatory requirements of a lot of enterprise use cases, you probably need some kind of KYC. So like a line of thinking we've done is like, okay, like if you want to register in certain cases, you need some like SPT saying that you've been KYC by some KYC provider, and maybe sign some kind of NDA, and like even beyond like whatever like cryptoeconomic stake that might be slashed in the Juror Misbehaviour Court if you misbehave, like the KYC provider knows who you are, and you can be held legally responsible. There's like a greater threat to revealing evidence inappropriately than just whatever you staked on the court. Like they can find you, and like maybe you have like criminal proceedings against you. And that seems fairly centralized. Like, okay, I'm going to a specific KYC provider. They give me an SPT. I can only be drawn if I have like the SPT, at least in like certain courts. This KYC provider is now like kind of like like a central actor in at least in those courts. And I asked myself like, okay, like what degree can we decentralize this? Like, can you have like similar security guarantees while still having some level of decentralization? And an approach that I'm considering, like maybe at some point in the future for like as the ecosystem of private evidence cases develops, you could have like a curated list of KYC providers. So maybe in like maybe there are different KYC providers. You use like private evidence cases with like Junin. Maybe Junin is willing to KYC people. Maybe not. Maybe like forward-looking companies like Lemon that like maybe they want kind of private evidence. So like maybe the company itself is willing to act as a KYC provider. The Kleros cooperative itself, maybe some kind of like forward-thinking like crypto-specific law firm is willing to KYC you. Maybe like other companies just provide this as a service if it gets big enough. And then if I want to like add a new KYC provider, I can like submit that to a list. And then you do the normal Kleros thing where like if the KYC provider is like not up to the standards of whatever court, like providing enough verification for jurors to be used in that court, then people can challenge that. You can have a Kleros case about whether the KYC provider should be allowed. And my metaphor for how I think about the level of decentralization in this system, it's similar to public key infrastructures, how certificates are handled for websites that use HTTPS, if you're familiar with that. So as like an overview, just briefly to like sketch the metaphor, when I like have a website that wants to interact with people through encrypted channels, you have like an infrastructure in place so that users of the website can know that they're not interacting with a spoof, like a scam, fake version of the website. And so if you go to like the Kleros website, which I have the screenshot here, and you click on like the two bars in the like upper left corner next to the URL, I think on Brave browser, it's two bars. I think on like Chrome, it's like a little padlock. You can see the certificate of the website. So the certificate gives you like a public key. It tells you like there's this entity, the certificate authority, which in this case is Let's Encrypt, which provided some due diligence on Kleros in this case before they issued the certificate to the website. And the thing is that like the browser has a list of certificate authorities that it trusts, which in this case included Let's Encrypt. So like my browser knows to trust like certain certificate authorities, and the certificate authority like will do due diligence on the websites that want certificates. So like if I have a website, I go to certificate authority, I get to pick from dozens of different certificate authorities. They do some due diligence on me, then I'm trusted by the browser. So you have this like chain of trust. And I see like we can have like a similar model where I have like a root of trust, which is my curated list of like vetted, like approved KYC authorities. Any one of them I can use to go to vet me. So if like one KYC authority for whatever is like censoring me, I can go to another one, and they will do the appropriate due diligence on me. So I have a chain of trust from the user to the KYC authority to the curated list. Okay, so that's all for humans. And then for AI jurors, the story is different in interesting ways. So I'll just wrap up by like sketching out how like LLMs and AI jurors can like deal with confidential evidence. So now imagine I go back, I have my dispute between Alice and Bob. they have confidential evidence, but now their jury of, their Kleros jury, their crowdsourced jury, is just like 3 AI agents. And you can do, like, Kleros works perfectly well in that setting. Like 3 AI agents can play a shelling game where, like, they try to, like, expect, okay, like, what will the other agents say when faced with this suit between Alice and Bob? Now, if I want to give, like, an AI agent like that confidential evidence, a thing you can do is you can use AI agents that have what are called trusted encryption environments built in. So this is a, like, hardware module. It is a piece of physical machinery that can be used to store encryption keys in ways so that the key, like, is not supposed to be able to leave the module. So if you imagine that I have, like, a data center where my LLM company is running their LLM, next to, like, the server rack where they have, like, where I'm interacting, pinging to, like, interact with my LLM. There's, like, some other piece of machinery attached, and it has this, like, physical property that it stores encryption keys really well. And even the, like, LLM company should not be able to get access to those keys. Like, if they try to, like, cut open the machine in their data center, the machine will realize it's being tampered with. It'll just delete all the keys. And then what you can do is, like, Bob, the party to the dispute, could do, like, a key exchange where now he's doing a key exchange with, like, the TE. The key comes from the TE, can't exit the TE, but, like, Bob can use, like, that, whatever the TE's public key or whatever, to, like, send his confidential documents to the TE. Like, only those documents will only be decryptable within the TE, and the TE can, like, reason about them. You can put a model of the LLM, like everything operating inside the TE, and it will give a resolution to the dispute that is sent out. But, like, none of its, like, reasoning, including the evidence, will be visible, including to the company that made that owns the TE and is running the LLM. There's an example of an LLM that works like this. It's called Confer. There's at least one example. There may be others. And their sort of business model, they're kind of, like, branding is around, like, having, like, a private LLM tool. If my conversations with the LLM, they only are, like, decrypted within the TE. Nobody else can see them, including the company can't, like, mine my conversations to, like, get data on me. So you have, like privacy guarantees. And you can adapt basically what Confer does. Like, some adaptation would be required. Their model doesn't totally handle this setup, but, like, it wouldn't be intrinsically more difficult. You can do, like, a setup where I have the party to the dispute, and then I have a human juror, like a human P&K holder, which wants to run an LLM as the juror on their behalf, and at least in this court, like, both, like, the TE can generate 2 keys for both Bob and the juror, and the Bob will obviously send his encrypted evidence. It goes to the LLM. Nobody else can see it outside of the TE, and the juror also has sort of secrets that, like, if he's putting into this, like, conversation with the LLM that he doesn't want to just, like, publish around. He has, like, his prompts that he's going to use to interact with the LLM. Like, ultimately, from the juror's perspective, like, kind of like how you get an edge compared to the other jurors, how you operate like a good LLM juror is a matter of, like, which LLM you picked. So here that's kind of fixed. You pick the one that had the TE capacities, and then, like, what prompts, what skills, what you feed into the LLM. It's kind of like a workflow to make a good resolution. And you don't want to just publish those because that's your sort of secret sauce and your edge against your competitor. So the juror also encrypts that and sends it to the TE. And the TE, like, has access to the prompt and the evidence. It can make a resolution. It can publish a justification that comes out, is encrypted under Bob's key, so that only Bob sees the justification. Maybe the justification references, the secret evidence, and nobody else ever sees anything else. Like, to the degree that you can trust the security properties of the TE. So, like, this also has some centralization elements. These, like, TEs are made by companies like Intel. I think NVIDIA makes them. There are others. And, like, you depend on Intel providing, like, a good enough TE. The users, like the juror and Bob, can do a sort of exchange of information with TE to determine that they are actually communicating with, like, an LLM that is using a TE. So you can get guarantees that like, okay, like the LLM is acting what it's supposed to do. It's using the latest like this Intel TE, but ultimately like, you know, you can verify that against some like Intel's public key, but you're still depending on Intel. You know, if Intel makes like a malicious TE, you know, like that would completely circumvent this process. So like some centralization trust like assumptions, you know, are not amazing, but like, you know, maybe you can live with in certain use cases. Around the TE manufacturers, maybe you don't want to just trust like one TE manufacturer, but then again, you could do like, you know, sort of same as before, maybe you could have like a curated list. I'm not required to stake in a given court to just use like the Intel TE, but like maybe like, you know, I'm allowed to use like any LLM that like has like these properties, you know, which may be offered from multiple different offers. You know, we can have like curation disputes about whether like a given LLM meets the requirements. Okay, so that's pretty much all I have to say. You know, just to like highlight again, different approaches you can apply here. Cryptoeconomic things like penalizing people through the Juror Misbehaviour Court. There are also these like decentralized voting ideas, and then these like AI tools provide new opportunities that depend on trusted hardware, but can be interesting in some use cases. Okay.
Thank you, William. That was amazing. And so it's a great thing that we could give people a bit of an overview of the type of research we are doing for privacy. And one of the things that, as you mentioned, you know, partially this is cryptography, partially this is what we do every day, cryptoeconomics, economic incentives. What is the cost for me to really leak evidence, etc. And partially it's a legal solution. So we have seen how in some cases, we have jurors sign contracts of non-disclosure agreements. So we have Facu here who can tell us a bit about how we are thinking about the legal elements of this mechanism. And well, I mean, in which sense currently confidentiality is a friction point for Kleros, and how this can be solved through this type of research. Yes, go ahead.
Yeah. Well, as William mentioned, Kleros disputes normally live on IPFS, and that's problematic in the sense of being able to comply with data protection regulations, specifically if we're talking about GDPR compliance. And when we are talking about Kleros enterprise use cases, in which we connect with governments and enterprises, then this becomes a challenge. Right, so developing these private courts are mandatory if we want to go forward in this direction. So instead of posting evidence to IPFS, what we do is we keep it in a GDPR compliant virtual data room, which is treasured, and that also applies end-to-end encryption, and the evidence is accessed only by SBT certified jurors. We call this SBT digital credentials. And for them to be able to access this evidence, they have to comply with the requirements of the court, of the specific court. For example, if we are talking about the Consumer Ombudsman Court, they have to be either lawyers with experience in consumer protection, or they have to have experience in dispute resolution, for example. And if they meet those requirements, and if they agree to the terms and conditions, we basically are some kind of code of conduct, like the code of conduct that William mentioned, and then they are granted access to this court, and they can see the evidence in this in treasury. So in this way, we have developed like a proof of concept. It's not perfect, as William said. It has its trust assumptions and centralization points, but it's a first step towards this goal of having more private setup that will unlock these amazing use cases. It will help us achieve more partnerships and with governments, with enterprises that need to solve disputes that are around sensitive information. So this is amazing, and hopefully this will lead to more use cases. Yeah.
So as Facu mentioned, this is still a proof of concept, and we have a lot of questions we ask ourselves of how to build this. And we have opened now like our 10th batch of the fellowship, and then people can apply. One of the tracks that we want to incentivize people to apply to is the privacy track. So if you are interested in this type of topics, you want to help Kleros be more adopted through increasing the privacy elements in it, apply to it, and you can do it from the point of view of cryptoeconomics if you want to do that type of research, or you can do it from the point of view of law, maybe to do research about how this can interact better with legal frameworks. Maybe, William, you can. What are the most biggest challenges to the type of mechanism you are building for privacy, so you can motivate people to try to research around them? What would you say?
Yeah, I mean, it really depends on which of the approaches, because, again, like I've tried to present like a toolbox. There are like all these different approaches. Some of them are complementary. Some of them are kind of for different use cases. I find the sort of AI stuff, interesting. It's new. Like we didn't have these ideas like a year or two ago. I mean, to some degree, it's dependent on like the fact that LLMs have improved as potential jurors. But there's all these interesting sort of key design questions around like, how can I handle this sort of like TEE LLM in ways that have good UX for parties and for jurors. It's like not too hard theoretically, at least I think, I'm not like a hardware person, to do this in a way that has bad UX. But if you had like, having good UX is, had their interesting research problems. So, if there's anybody who has experience with like AI and like hardware, like security, I encourage you to think about that. For the sort of other more cryptoeconomic things, I mean, like to some degree, like good policy writing is like important for like, okay, well, what exactly the policy of the Juror Misbehaviour Court, and how do we like, what exactly should the Juror Code be? The mechanism itself isn't so complicated. It's like, okay, well, we're going to slash you if you get convicted. Maybe there's some interesting questions around like, okay, like, like my negative soulbound tokens, like, exactly how should that work? Should I have like a 3 strikes policy? Like there are some interesting questions there too.
And Facu, from the point of view of the legal elements, what should we encourage people to come to the fellowship to research on? I mean, there's lots of data protection lawyers who follow us. So what would you tell them if they want to research this?
Yeah, it will be amazing to have experts on data protection, especially from the GDPR point of view. And yes, maybe a combination between someone with the expertise that William is mentioned, and someone from the industry, from the legal industry, having both minds working on this, that would be amazing. And yes, I think that's it. This is mainly focused on data protection regulations. So I will encourage anyone who has experience in this field to apply. And if you have any questions, feel free to reach out.